briefly stated are that that landowner the owner of land. What is the extent of land? The owner of land. What is the extent of land, Mr.? Landowner is the owner of land measuring 8 acres and 20 guntas, 28 guntas situate across survey number 24. 24. Huh? Situate across survey number 24. And land measuring 6 acre and 9 guntas of survey number 25/3 and land measuring 59 guntas of survey number all is here written. Huh? 8 acres and 28 guntas. All right. Landowner was the owner of land measuring 8 acre and 28 guntas of different survey numbers situate in village. What? Uh, early village. What taluk? Bangalore South taluk. You had you had entered into settlement. That's what we are asking. Good timing. If you are not asked upon to argue, it's better to please sit down. Please. The problem is that if we dictate in your presence, you interrupt. When we don't dictate, you say the orders are not dictated in our presence. What to do, Mr.? I only asked in respect of how much land you have entered into a settlement. That's it. That's it. Not that without understanding we are dictating the judgment. So thereafter you will start arguing. If you want to argue, then we will admit his appeal. All right, then delete everything. Yeah, yes. Argue what? You are appearing for which respondent? Yes. An acquisition officer. Huh? Huh. Argue, sir. Argue, yes. He has relied on Banda Development Authority. What do you say? 2011 5 SCC 394. What do you say? He has relied, he says it was an open land. Preparation of a Panchanama is the standard method which has been approved by Supreme Court in Banda Development Authority. So you are for respondent, contesting respondent, right? Then why do you want to argue? That we know it is written in the order passed by learned single judge. Don't want to argue anything. Except saying that settlement in respect of 2 acres and 2 guntas. The KIED. Yes. And number 1, landowner. Yes. Yes. Then there was buildings, not a waiting. Delete. Appeal is admitted for hearing. Huh? Huh. What was the suit?
It's an Indian correction technician.
Appeal is your appeal is admitted for hearing. Notice on behalf of respondent is accepted by learned counsel. Office is directed to secure the record of the trial.
Yes.
These people think man must be having experience of say 20 years, 25 years. The question is, what does it mean? Just to think unreasonable. Yes.
Twice appeal against rejection of her petition for monthly meeting, a petition for divorce grant.
With respect to record. There is a procedure, right? No, merely because in this, and please wait, your colleagues in 2016 and 15 matters will seek adjournment. And merely because you want it to be heard today, order to be delivered in your office by 2:30, duly signed, granting maintenance of 1 lakh per month. So, it, you are aware about the procedure. Notice has to be served on them. When that notice, you first have to pay process fee. Perhaps we should have some astrologer also in our this thing board branch section who can calculate. We should give details. He will calculate what time the notice will be served. So then he should tell us that as per your horoscope, the notice will be served on respondent by this date. Then we will fix immediately next date for final hearing. He should also suggest us what should be the date on which it can be heard. And the counsel for respondent won't seek an adjournment. Like all this. Think about it. Give us suggestions so we will implement it. Yes, sir. This is 23 appeal. It has just been admitted. Record is yet to come, and you want a date for final hearing.
Second starts.
The time. Which time is granted to comply with office objections, failing which appeal shall stand dismissed without reference to settlement. Without reference. What happened? Settlement. Meeting was held not with the accommodation. How many times? 26/5/23 you sought weeks. Again, then meeting took place, this happened. We are not interested what happened. We have to decide this in accordance with law. We are not concerned what happened and meeting happened. Why did you seek then only a week's time if you knew that it won't be concluded? So you argue, Mr. Better to argue. Forget about settlement. We'll fix a date for hearing. Forget about settlement. Ah. How many times it has been adjourned for settlement? Next date you either argue or this. You report settlement or argue. What date? What date? It is convenient we come to court every day. It's your prerogative not to come. We don't have a choice, right? We come to court every day. You tell us the convenient date. Take it. We don't want to take him by surprise that he was about to tell us what happened and this happened and morning meeting what took place, evening they didn't come. So we are giving him time of date of his choice. Which date? Yes, Mr. Huh? It is not the previous learned senior counsel for the counsel correspondent case for adjournment. It is made clear that on the next date of hearing, either the party shall produce the settlement or uh, shall address the argument on merits of the matter. This on 19th of June 20. Saying next week. They are asking. We don't know why in next week, but he's saying next. We don't know why he wants it next week. He hasn't told us why he wants next week, but looking to his age, what's the problem? Some issue, health issue. The council, cabinet, raised for it only. Just next week.
What is drying? What is drying?
Next week. You want it in the next week, right? Number 4, Sanjay Liye. Because take on.
Respect of respondent number.
Service of notice on respondent number 1 is held to be sufficient. Memo is accepted. Bye. Is acting here. Yep. Next. In view of the made by learned counsel for the applicant, this objection is ignored. Issue notice of IA 1 of 22 and 2 of 20. For analogous hearing along with here, give it. Give the number. Huh? Right? When learned counsel, the applicant submits that the process fee has already been paid on yesterday, 6th of June 20. In order to continue. Most important thing, right? Interim order should continue. Yes. Okay. Okay. Yes, Nagaraj. Learned counsel for the applicant submits that office objections have been complied with and process fee has been paid on 6/6/23 in view of offensive submission office to proceed further. A 1 of 19 is taken up for consideration. None has IA 1 of 2019 is taken up and 3 of 2019 is taken up for consideration. None has appeared on behalf of the respondent. Neither anyone has appeared on behalf of respondent nor any objections to the aforesaid IA have been filed. Line below. For the reasons assigned in the application will be supported by an sufficient cause conduct to delay of 35 days filing of the IA 1 of 2019 is allowed. What state?
It's a period resolution.
Even also heard on IA 3 of 19. In the meanwhile, operation effect of improved judgment and decree insofar as it pertains to term of marriage shall remain stable. About 22 days, same order, 10.1. Delay of 22 days in filing the appeal is condoned, IA is allowed. Then say both appeals are admitted for hearing. Issue notice. 11. One side. Why? Huh? Settlement. So you don't want to it through mediation. So how does he know that it will take 4 weeks? You will take 4 weeks. 4 weeks. Learned counsel for the parties. With that, the dispute between the parties is likely to be amicably settled. They therefore pray for adjournment. Please stop for 4 weeks. What leave to file? You are senior. It is IA 1 of 2 of 20. Leave. Why? You are not party. Why? Who are you? How are you aggrieved by the order passed by Learned Singh? What's your name? You need counsel for the applicant. Heard on IA 2 of 21, 4 of 21, and 5 of 21. Issue notice to respondent. You are senior counsel or not? This order we would have passed if senior would have appeared. Who said you come ready? Always come prepared. Don't I ask you? Is done for the so for the applicant. Issue notice of IA 1 of 22, 2 of 22 record. Okay. Notice of IA 1 of 20, notice on IA 1 of 22 record. Bill Prasad Payas Learned Counsel for the applicant. Notice of IA 1 of 22, 2 of 22 record. 16. Notice of IA of 22 record. 17. Party section.
I represent the respondent melodies.
You are appearing for respondent.
Respondent melodies.
So yes, early hearing application. What date?
My lords, any date may be fixed, my lord.
Tell any date in week commencing 19. 19.
In 2 weeks, any date may be fixed, my lords.
19 June, Mr.
19. Oh, oblige, my lords.
Heard on IA 1 of 2023, taking into account the nature of controversy involved in this appeal, IA is allowed. Let the appeal be listed for final hearing on 19th June 23. Nothing in the appeal of what? Huh? Nothing. For the appeal. What's your name? Learned counsel for the appellant. Mark his presence. Huh? Learned counsel. Learned counsel for the appellant has filed a memo seeking leave of this court to withdraw the appeal. The aforesaid memo is taken on record. In the result, appeal is dismissed as before. Rejected. Weak. Read para 14 last 3 lines. No, it is pertinent to mention here that then read, then read further, read further. See, the difficulty is that you yourself appeared. Para 15, read para 15. It has been recovered from you. Then what survives? So the amount in respect of which you sought a prayer under section 9 has already been recovered. Is it been? What survives? By way of section 9, the court cannot grant you the relief to refund that amount to the respondents. And that is all subject to the proceeding before the arbitrator. If arbitrator finds that that amount has been illegally recovered from you, he will direct refund along with interest. What section 9? Nothing survives. Understand? This appeal under section, mark this presence, this appeal under section 37 of the 13(1) and 1A of the Commercial Courts Act has been filed against an order dated 19th of January 2022 passed by the Commercial Court, by which petition filed by the appellant under section 9 of the Arbitration and Conciliation Act has been rejected. Paragraph. It is not in dispute that amount in respect of which the appellant sought the relief under section 9 of the Act has already been recovered from the appellant. Full stop. The validity of the action of the respondent in recovering the amounts from the appellant shall be adjudged by the arbitrator, who may be appointed by the parties to adjudicate the dispute. Full stop. At this point of time, nothing survives for adjudication in this appeal, as the amount has already been recovered from the amount in question has already been recovered from the appellant. The appeal is therefore disposed of. Notice the court office is directed to secure
22. FRC.
issue notice. Came out.
My lordship, I am the caveator and the respondent in this case.
Yes, ma'am.
The copy of the petition has not been served on me till date. I have not been served a copy. If
Right.
directions may be.
Yes, we will direct them to serve a copy, but nobody is there. Please wait for a while. Just 5-10
obliged.
minutes. Please wait. Other counsel is not there. We are passing it over, right?
Much obliged.
English language.
To the patent illegality in the award.
But I find that it was anticipated. It is not going to put a claim on it. But in the no point when not he made the objection, that it was well known, it was white. The award was passed. Only in so far as granting of break claims of what he can be about. Not can be about this granting this claim. Then this one was not in section 2, right? Because I have the arbitrator. The virtual working is not the whole arbitrator. The Delhi High Court did not reach the point where object. It did not, section 34, which is not responding.
What is Perkinson's judgment?
Laws not there. So it's need to appoint an arbitrator, but it's why not the judgment is taken. The Delhi High Court distinctly saying, but in section 14 of our section 11, in section 34, when he participates, files a counter claim. But in which case, he is not waiting there. That's the
Should notice. Presence learned senior counsel for the applicant, that he should notice. One thing, Mr. Senior Counsel, you said that Delhi High Court has explained, Delhi High Court cannot explain the judgment of the Supreme Court. The Supreme Court alone can explain its judgment. Delhi High Court is not about Supreme Court. You told that Supreme Court judgment has been explained by Delhi High Court. Understand that? Right? We just wanted to point out. I mean that may not be correct way of putting things. You are relying on that judgment, it's a different thing. But Delhi High Court cannot explain Supreme Court judgment. That's what we are telling you.
And by Delhi.
I appear for respondent number 1, Your Honor. I appear for caveat respondent number 1, Your Honor.
It is on behalf of respondent number 1 is accepted by Mr.
A. Murli, Your Honor.
A. Murli, learned counsel, appearance on caveat. Service of notice on respondent number 2 is dispensed with, as the respondent number 2 is an arbitrator. Office is directed to secure the records of the trial.
I see.
Very peculiar. Caveat.
Your Honor, I seek 3 weeks time for
1 minute.
filing.
1 minute. 1 minute. 1 minute, please.
Yes.
I have no faith in this in the judge. Prove him wrong. Anticipating and downward step, we are complete. Right. Yes.
Your Honor, I seek 3 weeks time to file objections to IA number 1, Your Honor.
Learned counsel for respondent praise for is granted. 3 weeks time.
Much.
For record to enable him to file objections to IA. Yes.
Passover matter, number 18.
What happened? For the applicant, even when the matter is called in second his presence. Yes, not interested, dismiss from. Yes. Well, which
Number 23. The Sharona, yes.
hey, you supply a copy, she is appearing on caveat. Appearing on caveat, right? Huh? Oh. Yes, filed the caveat. Is she not entitled to copy? Learned counsel for the appellant undertakes to supply copy of memo of appeal as well as IA 1 of 2022 to party in person during. Madam, you need not hold your hands like this. Please relax.
Yes.
So, huh? You reside in Mangalore?
I reside in Bombay, but I have a corresponding address in Mangalore. They can serve it in the Mangalore address, Your Honor.
Mangalore address. Shall supply to party in person at her Mangalore address. You send it by courier. Simple. So when should we list it?
In the first week of April, if they serve a copy within a week's time, should be good enough for me
First
to serve
week
my
of?
doctor. First week of July, sorry, my lordship.
Like, yes, Mr. It's on 4th July.
Can it be 2 days later, 6th July, if my lordship allows? Because I have another hearing here.
Oh, rest of the day. So you are a busy person having hearings in the court. Huh?
My lordship, last 12
Sixth
years,
of-
the opponent has
all
made
right.
me run around between High Court and the trial court from Bombay all the way because of this injunction suit that they have filed. I have not been allowed to go to my own matrimonial house purchased by my parents. So this is the biggest trouble that I've been forced to go for the last 12 years.
Placed on 6th of July 20.
Much obliged, my lordship.
Also, 2,59,000 paid. Notes we had made when next.
Party dictated, that's
Okay, amount calculating.
out of that, 5,58,000, they have paid to the bank balance and statement. 2,98,000 is government data state was required to make a statement whether the balance amount is also paid or not.
So he paid 2,59,000. Paid or not paid? 1 minute, we have most are not there, we have forgotten. Yes. There are still 3 rounds of litigation. First petition is 7879. Seven eight four nine.
Implemented. It's 78. That was this is a little bit. This is the operative person job. Okay.
We have been filed. Petition. Just from bottom.
Gratuity.
Giving interest only.
Yes. Yes. Even the connection making reference to the case for 80. Department makes a calculation. It will be calculated. According to the department, 8 lakh is 5,58,000 is them only. This will be 98%.
Yes. That has been quashed. Percent interest on this amount. On which amount? Percent interest on which amount? Is the amount you are claiming? You don't even know, Mr. 3% interest on what amount? You are saying pension amount. Pension amount according to you is different. According to them is different. We don't want you to come again. The petitions you have already filed. This fourth one. And you want to tell us, be clear. 3% of interest on how, what amount?
Referring to this particular clause, which says amount is paid within 3 months, rate of 12%. It's not paid in that period, in 3 months. The escalated
So
rate of-
when was the amount paid? Therefore, you have to pay 3 as per. Yeah. Fine. Correct.
You want to pay only 12%.
Comply. Huh? You are a pro-employee government, right? Huh? No. Welfare state. Modern welfare state. Can't fight a citizen for 3%. And there is an order, right? And his employees no more. His widow. This intra-court appeal is filed against an order dated 18th of June 2019, passed by Leonard Single Judge, by which writ petition preferred by the has been partly allowed. The communication dated 24/7/2010 seeking to recover sum of rupees 80,509 from the petition. An appellate has been quashed. The learned single judge has further directed that any amount due to the appellant shall be released within a period of 8 weeks. Paragraph. Facts. The facts giving rise to filing of this appeal are the facts giving rise to this appeal briefly stated are that husband of the appellant, namely late Shri Ranganath Rao, joined the services of National Law College at Shimoga as lecturer on 4/10/1972. The National Law College is private educational institutions It's a educational institution which is recognized and aided by the government of Karnataka. Full stop. Husband of the petitioner, the husband of the appellant, uh, retired as reader in law, attaining the age of superannuation on 31/5/1994. Full stop. The retirement dues were not paid to the husband of the appellant. Full stop. Thereupon, the husband of the appellant filed a writ petition, namely WP number 850/2006, which was decided by learned single judge of this court by an order dated 24/6/2008. Paragraph 4 of the aforesaid order reads as under quote. It is not in dispute that the aforesaid order has attained finality and binds the parties. Full stop. It is also not in dispute that in compliance of the direction issued by learned single judge, the amount due to the appellant, namely the widow of the deceased employee, was paid to her on 3/4/2009. Full stop. Since the amount due under the order dated 24/2/2008 was not paid to the widow within a period of 3 months, therefore, the same carries the interest at the rate of therefore the appellant is entitled to receive an additional 3% of the interest in terms of directions dated 24th June 2008 issued by learned single judge. Full stop. Paragraph. It is therefore directed that the respondents shall pay interest at the rate of 3% on the amount due to the amount due to the appellant as retiral dues at the rate of 3% for a period from 1/6/1994 to 30th January 2005. The aforesaid extent, the order passed by learned single judge is modified. In the result, appeal is allowed. Andhra Pradesh? No Supreme Court. Then once Supreme Court says that writ petition is maintained. Yes. It is citation. One 06. Page 10. Set 10. 15. we would like to clarify. Point 11.
Effective way of doing this.
Yes. Pigeon bench, not double bench. Thousand. Yes. And yes, it can't be entertained. Fine. Which para? Para 14. AIR 2009 Supreme Court 208. 628. Sorry. AIR 2009 Supreme Court 628. Where is that order? Take it. So, Mr. No, we want to understand what is like where it is said para 4 and 5. Please read where does it say which Supreme Court decision has said that writ of habeas corpus is not maintainable. Where? Even this Home Secretary or to which reference has been made in para 4 also, it doesn't say so that writ of habeas corpus is not maintainable. Where from this proposition has come and you have to justify your objection has been accepted that the person can only seek a writ of certiorari and not habeas corpus. That means habeas corpus will be rendered redundant, right? Writ I which preventive detention. Which is that's what we want to know. Which judgment of the Supreme Court says that a writ of habeas corpus in case of preventive detention is not maintainable and only a writ of certiorari will lie. Please tell us. That we have also not come across. That's why we are putting. Then, Mr. What? We have read this Home Secretary's judgment, para 4, para 5, what they have quoted. I mean, there is nothing which says that in case of a preventive detention, the writ of habeas corpus does not lie. Nowhere says. And he has gone a step further. He is not Mr. Hegde, he has gone a step further. Last time you remember before vacation, he argued that if an order of remand is patently illegal, then also writ of habeas corpus lies. So, then he is not. So therefore, Supreme Court is expanding the scope of writ of habeas corpus. These decisions on which division bench has placed reliance nowhere says that a writ of habeas corpus won't lie. And you have seen this. We will obvious. We will say. Right. We will have to say, you are raising this objection, we will have to say that this is per incurium. And therefore it will find us. No, but before saying so, we want to know which judgment of the Supreme Court says that in matter of preventive detention, a writ of habeas corpus won't lie. That he has cited two decisions to say, and it is mentioned. It is mentioned. Andhra Pradesh full bench says so, lying on this case. No. Supreme Court has said Mr. in Deepak what?
Bajaj.
Deepak Bajaj. Celebrated writ of habeas corpus has been described as a great constitutional privilege. Mr. But Mr. On your behalf, this objection was raised that a writ of certiorari lies, and now you seem to agree with us that. No. Please. See, learned additional advocate general has raised a preliminary objection. Is your objection that writ of habeas corpus is not maintainable? We are asking which judgment of the Supreme Court says this. We don't know where from division bench has come to this conclusion. We will We will see to it that your difficulty is no longer there. Because see, Mr. These judgments do nowhere say that writ of it. How can Supreme Court say like this? Can't be. Huh? All this technical objection that you should seek certiorari and all that. And these judgments to which have been quoted, we have read whole of it. See para 4, Home Secretary. Where does it say that? And Anu Sanyal's judgment also 73 doesn't say so. Whatever has been quoted by division. Huh? We want to understand division bench has relied on judgments referred to in para 4 and 5. Correct? And para 6 it records a conclusion that writ of habeas corpus does not lie in case of a preventive detention, only a writ of certiorari. We are asking which judgment Supreme Court has said. Para 4 and 5 definitely no. Supreme Court has not said so that writ of habeas corpus. We don't know where from division benches got this, that only a writ of certiorari lies.
You have copy for sure. I think it is also preventive detention.
Yeah. Yeah. Okay, both sides also preventive.
Section 3.
Hmm.
The Supreme Court judgment is related to it. Musabina's case is relating to preventive detention.
Yes. Yes. Which he has relied. And we don't think it's all. We are surprised. One thing. Come to para 7, first 3 lines. Right. So petitioner in that case, where you took objection, had sought a writ of certiorari. So why did you raise an objection? He was already seeking a writ. He had not sought a writ of habeas corpus. Why did you raise an objection? Writ of certiorari is maintainable. Para 8 says, 7 says, he was already seeking a writ of certiorari. So there was no occasion for you to raise an objection, and consequently no occasion for the court to examine the question whether or not writ of habeas corpus is maintainable. And it does not take note of, we are sorry, but we will have to say so that this is per incurium, what else can be done? If you are so we will ask you, what is your stand? You are agreeing before us that there is no judgment. We will say so. Yeah, of course you can't say, but the fact remains that there is no judgment of the Supreme. We will say that no judgment of the Supreme Court has been brought to our notice, saying that therefore, and this in that case he had sought a writ of certiorari. You could have raised an objection that he should have sought a writ of habeas corpus, not certiorari. But you have taken, I don't know. He had sought, therefore there was no question to examine whether all this is missed in the matters of liberty. These are all like technical objections. Then, what
State again contradicts.
we'll say that.
So the reading is First is representation detailing authority. So the representation detailing authority has to be considered immediately at the earlier.
So you tell us 1 minute. When did the representation? 2nd January.
Government.
6/1.
Share the money. That Delhi had
5th January. 5th.
5. The same was served government on 6. The presentation is said that the first 2. There will be 6.
When
5.
when your representation decided. When it was. Okay. Correct, Mr. 3rd February. Then what is that Ashok Jala? First copy first. That judgment. Which page, Mr. Then Taha representation must be decided. Yes, Mr.
Detaining. He has not given detaining. This case is that he has given government. And other scenario is that will if that also parity, you not
Where is the judgment? Mr. You are relying on the extracts only.
Yeah. Ask the government. We go to the proper for the appropriate government to wait report to the board. Right? At the same time, especially in board officer who had acted detailed authority. Detailing authority, namely, especially in board officer and to the report in such situation, there will be a responsibility to state about the amount of the second. However, such is as 16. Must be. We agree with the observation and sustainability in time absolute or excessive. It is depends upon the necessity, the time. There may be The after the
Did you refer? Okay. Fine.
Detention order set the element member of cabinet is not 2-1. 2-1. Not 6-1 was his representation. According to him, the 2-1 itself, he has given his bail authority.
And this recommendation of the advisory board is dated 11th January.
By that,
But it, when it, how can 2-1? He has submitted on 5th of January.
Second, he has given a superintendent. And it was this government on 6/1/2023. 6/1/2023.
Correct. But
Therefore,
when have you forwarded this to advisory board representation? When?
that is on 1/20. Immediately after receipt, we received the 6 immediately. Why?
Not 5. Actually, where is the case also it was not there. Where is this?
5-1 is not forthcoming in your list of dates. This is not there in your list of dates.
Yes.
Yeah,
5th of January, you forwarded the representation to advisory board. Huh?
yes. There is no And this judgment would say the address to the government. At the time I was advisory board, the representation has been uploaded to the advisory board. And after receipt of the file only, you know, consider the representation. After getting the opinion and after receiving the file, you have to consider. You have considered it. And you have given the endorsement. Because 3/2/2020 checked it. There was only 13 days delay. So only 13 days delay. Judgment, other judgment. What? Last judgment.
13 days out.
13 days. The date of receipt of the advisory board. The date of consideration.
Did you receive the, when did you receive the advisory
The
board?
report of the advisory board was say on 21/2023. January. Then, end of delay of 19 days has been considered in the page number 16 and 20. Para 15 and 20. Page number 73. See. Instant case. Para 15.
82 is no para 16, it's 19,
Para 15. Page number 80.
81. Instant case. Ah,
In the instant case, and yes, the delay was caused the the entire fact, it should not be this case, the detention therefore, 13 days delay consideration of the representation after receipt of the opinion of the advisory board. But it's
not give the record of. No, your ground was that representation has not been decided.
this presentation was
You know, Ankit Ashok Jalan, what Supreme Court says that if they receive the representation before matter is referred to the this thing, and if there is no time, they have to forward it to the advisory board. So in your case, Right? No, Mr. That's what we.
But it's not decided. It's not. I thought might have not there with me, or that I not make. That is that even the details they are provided to me. In those details, though they are not mentioned yet, then they have forward the representation. There is a section of paragraph 60 they have mentioned it, of the details.
Says that on. Says that it has been forwarded on 5th of January.
The reason is jail authority himself has unfit. Letter is there in the jail authority letter is not.
Which representation you have? It is the representation submitted by wife or petitioner. Wife. Wife has submitted on 2nd January. It has been forwarded. Or representation, sir.
My wife representation because they have no way for pension. For that reason, only I think section they had received this representation on 6th January. They have received the representation. And there is a no date provided when it was forwarded to advisory. There is a we have sent the representation to the authority as well as the government to advise. All the 3% we have sent not only the petitioner as well as the reviewer. That representation must be the
Which page? 113.
there is a advisory book has already done the entire board and also the board
Distinction is para 14. Of law, no dispute. You all know. Facts. Para 14. Facts of why there was 6 months delay deciding the representation. That's why this court said that quash the order of detention. In your case, there are two things, Mr. which you must answer. Right? What they say is that your wife submitted representation on 2nd of January. it was forwarded to the advisory board on 5th of January 23. Right? And thereafter, the receipt of the recommendations of the advisory board within 13 days, your representation has been decided. So there is no inordinate delay in deciding the representation which would affect the order of detention or would vitiate the order of detention in law. This is the submission. Please tell us now how.
This need to all the delivering for American is. We have other.
You are an expert, right, on this subject. Huh?
Expect.
Not expert.
And then if we do,
We are also learning every day, but and we have told you what is it.
is not that.
Need to go through the judgment, right?
It was let down in the, very clear.
All right,
Regulation to the scene.
for your satisfaction, we will hear you at 2:30. But this is very clear, right? What we have told you. You understand? What they have told is that your wife had submitted representation 2nd January. It was forwarded to the advisory board on 5th of January 23. Advisory board has considered the representation. And after receipt of recommendations of the advisory board, your representation has been decided within 13 days. So there's no inordinate delay. These questions will have to be decided with reference to facts of each case, right? Understand? The decision you are relying in that case, even after receipt of representation of advisory board for 6 long months, no decision was taken.
Dates they are mentioning only, it was not provided to you.
Ah.
Even that those dates that fifth day or forward date, it's not provided to you. Otherwise, I have to reply again.
Please, 2:30.
Yes. Section to get it. Please, like you are not aware.
All right, 2:30. Right, 2:30. What you have argued, right? Your colleague. Your that or what? Or yes. What happened to that order? Handed over. Child is in whose custody? They don't keep it with you, right? Police custody, child to be kept. Why police custody? You give it immediately. What is there? You have to hand it over to the father. Ask them to do it. Mister. What is there? It has to be handed over. Keep this system. This final disposal 23. Okay. Yesterday's case.
Application for reference to arbitration has been rejected.
Agreement.
Agreement for providing manpower services.
It. 1 4. It.
First of April 2007. Page 58, clause 10. And at the bottom, sub-Roman 3. Please read. Any dispute arising out of this agreement will be resolved by taking recourse to mutual for arbitration in the first instance, failing which the dispute will be subject to Bangalore jurisdiction only. Trial court holds that this clause provided for an option between mutual settlement and arbitration. It claims to have attempted mutual settlement. It failed. Therefore, my lord, proof could be made. Fine. But my respect to contention. Mutual settlement. Mutual settlement was always a rule, because without requirement for a proof. Therefore, my lord, that those words ought to have been disregarded and not considered. In equating, my lord, mutual settlement, a non-binding, non-adjudicatory mutual settlement, binding and adjudicatory dispute resolution mechanism, arbitration. It could not have been equated and seen as two different options, is my respectful contention. This interpretation, arbitration clause obvious, signifying that it is
Any case law.
not in this scenario, but there is a judgment of the Honorable Supreme Court where there is an option between arbitration and court.
Yes.
Paragraph 4, my lord, parties should be settled through consultation. Consultation fails by treatment of the arbitration body for arbitration or the court. Just to kindly see paragraph 10. Page 777. Please read it. Para 10. The case at hand we find clause 15 refers to arbitration of court. As there is an option and the petitioner has invoked arbitration clause, and therefore we have no hesitation in the obtaining factual mediation of the case. Appointment is an arbitration. But there was an option. And when the party has sought arbitration, would have to go to arbitration. My respectful contention is I filed an application in this section. Arbitration. And one other alternate contention. Kindly see the claim. At page 20. That they approved the district legal services authority for pre-institution meeting. However, despite notice served on the respondent, they did not appear before the authority. Hence, the mediation did not start. But their contention was, since they have attempted pre-institution mediation under section 12A of the Act, mutual settlement has been attempted in this way. One pleading is that mediation never took place. They sought pre-institution mediation. My respectful contention, it is not a bona fide mutual settlement because it is a step in aid of filing a commercial suit under section 12A of the Act. So the intention was to give a go by to the arbitration that not be permitted.
The agreement, it's for section 7 of Arbitration Act. It's a mandatory part. And person is not literally binded or going to arbitration, any option sought by him should not prevent him to go for the Bangalore institution, as he has already read clause agreement. It shows two options. Either a person has to go to mutual arbitration. Now, the concern. He has initiated all this clear in mutual activity. In that regard, we have produced various details. He has initiated to settle the dispute through mutual settlement. He has even various emails to which is presented produced as annexed after in page 45. In page 14. From that, the email asking to settle the mutual. You have the very field, it never came forward for the settling. And legal notice legal notice even after receiving the legal notice. And all the options where we can set the mutual and institutional relation at this communication they have asked for their only go for the arbitration. But they even directly respond to the email communication requirement to that dispute mutually and stated in the agreement that once the mutual settlement process decision and settled decision. I just need to report. Commission my lord, the basic requirement requirement to file an application in the section 8 because the matter official agreement or certified copy has to be produced by the
He has not filed.
I rely on two judgments in my submission. Wellington Associates versus Kirti Mehta, which says when the options are divided, it is not a binding arbitration and all options will not be divided to arbitration. Page number 6, my lord. Point number 7. Very good.
Which parameter? There is no page number, we don't know.
The sections of the arbitration is and at that observation is made in the last paragraph. The word in the clause 1 of section 7 means an agreement by the parties to submit to arbitration. In my opinion, which makes a mandatory appointment of
Right.
section is where the parties agree that they may go to the suit or may also go to the. And option is that it's not mandate to go to the arbitration. Relying on. And Data Krishna versus Metro Engineering. Arbitration and conciliation at 19. Reference of dispute to arbitration. Original copy of deed not filed. Mandatory requirements under section 8 clause 2 not fulfilled. Matter cannot be referred to arbitrator due to non-compliance with the provision of section 8(2). No mandatory appeal. Officials are there with them. We have already seen the petition as well as acknowledgement on agreement.
Vote on this original having being required. Find a photocopy with the suit. You find an affidavit admitting that document. There's no dispute as regard that document.
That clause gives the this thing option.
My contention would be, in this latest judgment with the 2019, this design one, even where, there was an option. Even where there was an option. Party who wanted arbitration, was permitted to take the dispute to arbitration. That's one contention. Even where there is an option. Here, arbitration. Go to arbitration.
Here is clause 15 quoted.
Paragraph number 4, page 775, paragraph 4. Dispute handling.
Yes, madam, what do you say about this 2019-18 judgment?
This is handling clause which is mentioned. Settles through consultation fails by the treatment of arbitration. For arbitration. Means for year.
Option is in your clause, it also in this clause also before the Supreme Court. Option is there either in your case mediation or arbitration, right? And here also arbitration or court. Then also Supreme Court says that it has referred the what instead of deciding you should agree, madam. Arbitration is more, I mean, instead of
Initiation of proceedings happen.
When this objection was raised,
documents of dismissal admitted was no, but what is the ratio of this case? The court has not assigned any reasons, right? How do you meet that? She refers to a earlier judgment of the Supreme Court which says that after quoting section 7, it necessarily has to provide for arbitration. Mandatorily has to provide for an thing. This judgment, Supreme Court, only one paragraph 10. What is the ratio? No reasons assigned. Right?
Judgment where it has been done. And it is not. So Lord, you also consider this. Even in this case, Lord, the clause in this case, the word used is will. It is mandatory. Either mutual settlement or arbitration. One of those two is mandatory, and my respective contention is that the word mutual settlement should be disregarded. It is not. Mechanics is always available. Those words ought to have been disregarded, to not have been equated with arbitration.
One day. Here you go.
that interpretation, commit the road the party. Send an email, any message saying arbitration clause will be used and they will go back.
But what is it like? I mean, it says no earlier decisions of Supreme Court have said so. It should mandatorily provide. If she would have agreed, it's fine, but they have more faith in judicial system. They want to spend more money, time, everything, rest of their lives in court. We suggested that they should opt for any other person would have, instead of contesting the matter, should have agreed. But they have more faith in the system, more time, more money, everything, more patience. Yes, madam. Huh? You should have asked your client to agree for instead of fighting it out. Is it not a better this thing?
So forget about legal principles, think from practical perspective.
They are asking about this thing.
You are the plaintiff, you want some relief, right?
You should have a pragmatic approach. That's why we are instead of contesting it here, you may succeed, may not succeed. That's a different thing. But you should opt for this. It is a faster mode, right?
Suit is being then commercial system. Next one is the arbitration clauses that could be implemented. The plan of the plaintiff and
That we have understood, madam. You need not repeat it twice, thrice. We have understood, right? I think if you would have been presented by some senior counsel, you would have understood. You are only tutored to tell this that, so therefore you are repeating it. Yeah, madam, legally you may be correct. We are not saying, but pragmatism demands that probably perhaps you should agree for arbitration. We are not saying legally. We will decide it. You should agree. What is there? This suit and then appeal and this thing. Court fee. You have paid the court fee, right? So here they have more money, time, and energy, patience also to wait. What can be done? These two judgments are, they take a correct view. This is two reasonings have been assigned. And these judgments have not been taken note of. Only one line they say. We consider this. So we wish that by an interpretative process we could have arrived at, but it's not possible, right? Mediation now has a statutory recognition also, right? Under the both the acts, under CPC also it will be there, and then now under the Commercial Courts Act also. You can't say that it's mediation is something which has to be ignored. We can't do that. These words, this what however, not equate. Parties have agreed, right? Yes. This commercial. In filed under section 13 within bracket 1 capital A of the Commercial Courts Act 2015 is the order dated order dated 18/1/2023 passed the Commercial Court, by which the application preferred by the appellant under section 8 of the Arbitration and Conciliation Act has been rejected. Paragraph. Facts giving rise to filing of this appeal, we stated are that parties entered into an agreement on 1/4/2017 to provide manpower services. Full stop. Clause 10 of the agreement Plus 10 within bracket 3, Roman 3, Roman 3 of the agreement reached as under page 58. Paragraph, the respondent, it appears that the respondent resorted to, it appears that the dispute arose between the parties and thereupon the respondent resorted to of mutual settlement of the dispute which did not succeed. Thereupon the respondent filed the suit before the commercial court. In the proceeding before the commercial court, appellant filed an application under section 8 of the Act. You say arbitration conciliation herein after referred to as the Act. After section 8 of the Act, for reference of the dispute between the parties to the arbitration on the ground that that clause 10 within bracket 3 of the agreement between the parties stipulates resolution of dispute by arbitration. The opposite application has been rejected by the commercial court as order dated 18/1/2023. That counsel for the appellant submitted that mutual settlement, which is non-adjudicatory in nature and is always available to the parties, cannot be equated with arbitration, and therefore the commercial court heard in rejecting the application preferred by the petitioner under appellant under section 8 of the Act. In support of such submission, reliance has been placed on decision of Supreme Court, Honorable Supreme Court in 9 SCC.
7.
Upon the other hand, learned counsel for respondent submits that in view of the mandate contained in section 7, the clause in the agreement, the agreement has to necessarily require the appointment of an arbitrator. It is pointed out that in the instant case, an option has been given to the parties. Therefore, and therefore, the learned judge rightly, the judge of the commercial court rightly rejected the application preferred under section 8 of the Act. In support of such submission, reliance has been placed on decisions of Supreme Court in Wellington Associates Limited versus Kirit Mehta, KIRIT, Mehta 2000, it goes 4 SCC 272. And N. Radhakrishnan versus Mestro, MESTRO, Mestro Engineers and Others, ORS, Engineers and Others, 2010. It was 1 SCC 72. 2010, 1 SCC 72. We have considered the submissions made on both sides and have perused the record. In Wellington Associates Limited Supra, Supreme Court. Honorable Supreme Court noticed section 7 of the Act and held that section 7 within bracket 1 means an agreement by the parties to submit to arbitration. Parties to submit necessarily or rather mandatorily to arbitration. Full stop. It was further held that Section 7 of the Act does not cover a case where parties agree that they may choose one forum or the other. Full stop. Similar view. Full stop. In full stop. Paragraph. In the instant case, from perusal of clause 10 within bracket 3 of the agreement between the parties, it is evident that the um, same provides option to the parties to resolve the dispute by either taking recourse to mutual settlement or arbitration. Full stop. Arbitration. Full stop. In the instant case, the respondent has resorted to mutual settlement, which has failed. Thereupon, the respondent has filed the suit before the commercial court. Full stop. Clause 10 within bracket 3 of the Act does not mandatorily require the parties to submit to refer the dispute for adjudication under the to arbitration. Full stop. Therefore, in view of law laid down by Honorable Supreme Court in Wellington Associates Limited Supra, learned judge of the commercial court has rightly rejected the petition filed by the appellant under Section 8 of the Act, paragraph. For yet another reason, no interference can be made with the impugned order as under Section 8 within bracket 2 of the Act, as in the light of mandate, contained in Section 8 within bracket 2 of the Act. A party is required to file an original agreement. In the instant case, original agreement was not produced. The judge of the family of the commercial court. Paragraph. For the aforementioned reasons, we do not find the merit in this appeal, save bills and this. Yes. Where have you got this style from? Like tying it like. What is it? 10 years, 13 appeal, 10 years have passed. The moment the case is listed, you are certainly reminded of engaging a senior counsel. When this practice will stop? No. See, Mr. I was also designated as a senior counsel for my elevation, but I never accepted a brief in my name to seek an adjournment before the court. It's not, no senior counsel would accept the brief. And here routinely we come across this sort of a practice. The moment it is called for hearing, you will suddenly be reminded that I have to engage a senior counsel. Very good, right? So the day when the case is called, you withdraw, you file wakalat, then seek instruction. And then what is this? There is no question of apology. We are trying to tell you. Every day we feel as if it's our case. We will be getting something out of this, like if we decide. How you people are not bothered? Why your class question? We don't know. And how do you deal? What justification will you give? If the court was allowing the appeal with great difficulty, I got it. will remain the same. It's not going to change. You ask Mr. Lakshmi Narayan, he knows it will not change. No, Mr. Lakshmi. Then argue next week. This is 2010 years old matter. That's why we are reluctant. Doesn't matter. We would have adjourned 10-year-old matter if we adjourned. What like what ground? Senior counsel. Huh? Date give. Yes.
Received day before yesterday, I'm told there
Ah.
was no such submission made. I feel again,
Why did you receive? You did not ask the client that how will I seek adjournment and what will happen if the court refuses to grant adjournment. Receiving NOC wakalat in a pending matter for 10 years. Not. Supposing if we refuse to, what will you do? Go to Supreme Court with NOC wakalat. Huh? Use that NOC wakalat for filing SLP. We don't know what will be the result. We are yet to hear. What is this? Not fair. Not to be fair. Please do not. 10-year-old nothing to seek adjournment. We really. And what have you told my brother 1.5 years ago? VAR will cooperate. Huh? You are an officer of the court. You told him that VAR will give police cooperation in discharge of duties. Is this the cooperation? All the time, everybody here, see at 121, the courtroom is full. That shows all of them are sitting here to seek adjournment. 1:30, we will get up. They will say item number 49, item number 16. That's why it is good. They know that no cases will be called, but still courtroom is full. All they like you. They are watching what do we do in 2013 matter. They will say that in that case, 2013 matter, you have adjourned. Our case, you are saying no. That's the, you should understand, Mr. This is the predicament. And this hide and seek with the court will not help you. That it was listed on 5th of June, it was adjourned to 7th of June. In the meanwhile, instead of preparing the case, you obtained NOC wakalat and seeking adjournment. There's nothing great about seeking adjournment, right? Nobody remembers you. We will remember you provided you will argue it well. What is it? Tell us why it should be adjourned. Repeatedly, these cases, see all order sheets. Last is what date is next week you tell us
16th, no, the community wrote.
16. Adjournment.
Application I had moved for additional documents.
Ah.
For my friend will have no objection to that.
We will consider
Please.
16. No adjournment. Great counsel for the respondent once again prays for adjournment. By way of indulgence, hearing is deferred. It is made clear that no further adjournment on any ground shall be granted as appeal is pending for past about 10 years. This one 16.
Go I say 12.
16
Happen to be the responding to the other.
One is appealing in 15.
Appellant in 12 blocks, respondent in 7. Correct.
What? There is 1 hour, 2:30 we will take up. Let's see both. Huh? No, that's fine, but why do you serve when the why do you serve when the case is called? You have served her just now. So you are waiting, both of you waiting for case to be called and then immediately.
Also date given.
Date given.
It is letting only to alimony.
So what is it? Have you met him after the break? What is there? Why did you come to court? You could have asked somebody. You are. No, madam. You should see the order. Just now in 2013 matter, we have granted adjournment. Who tells you? See the order sheets. The court is granting adjournment in every case. Do you think that we are going to get permanent alimony by deciding your case? Here we ask them questions because we want them to argue. Is it not good that junior counsel should argue? For how long you will be there in the profession? Huh? So your junior should learn or not learn with you. All you see the order sheets, the adjournments in all cases are being granted. We do not grant readily because the moment we start granting it readily, 10:30, everybody will seek adjournment. That's the problem. Sit on the chair of the judge one day, then you will realize what is the difficulty, right? Sitting there and saying everything is fine. So since you are not well, we will adjourn it by 2 weeks that you can recover, right? No. I have 2 weeks. We are not in a hurry. Your object is to get an adjournment. We are granting adjournment. Learned counsel for the appellant prays for adjournment to enable her to prepare the case and argue the same list after 2 weeks. Right? Don't file it there. File it. Whatever. Will be ready.
Appearing for the respondent, my lord.
Ready. What is it, Mister?
In this case, my lord, actually, the earlier the matter was referred to mediation, then both the parties were present. The petitioner has stated that she is not interested in continuing the marriage, my lord. Therefore, we have to still decide the terms of the divorce, my lord, under mutual consent. They have been separated from almost 18 years.
What is the judgment?
Restitution, yes, my lord. Restitution of conjugal rights has been decreed in favor of the respondent. The appellant has challenged that for setting aside that.
Who is appellant?
Appellant is the wife, my lord.
Wife.
Yes, my lord.
Whether this decree for restitution has been given effect to? No.
No, she has not come back, my lord. We have filed the execution. Execution is pending. At that time, they have moved and they have obtained the interim order.
When the execution was filed?
Execution was filed 3 years back. Execution.
How do you have a
My lord.
password? Let's see.
Yes, my
Password.
lord. Yes, my lord.
18. Satish Chandra.
Yes.
19. Party. 18. Coming. Around yes. Take it up after the break. Repeat from 17. Break. We told, right? So many lawyers sitting, everybody for adjournment. Right? You want to withdraw? Yes. We don't know. Which case? Huh? You are not even there. We have to tell you what order we have passed. Very good idea. Don't appear when the case is called, then ask the court. Court will tell you what order has been passed. I think continued, he told me, it has been continued.